Good morning. This is James Phillips. We've talked a lot over the videos over this last couple years, and most of you know me as a military law attorney. And so today we're going to do a little fun Friday. I'm a little unshaved. I'm a little bit relaxed. We're going into the weekend, but I'm going to talk to you about some lawyer lies. So this is what lawyers tell each other, and when we're all getting together, we'll talk about our cases and we'll kind of share things that maybe the normal public doesn't hear, but I'm going to share it with you today. So years ago, and this is all public record, and so you don't have to look it up. I'm not telling you anything that's not that's confidential, but I was involved in a court martial, and I won't tell you where it was at, but one of my clients was accused of sexually assaulting basically his stepdaughter. And one of the problems is, as we got ready for trial and we were going to go to a jury or a panel in the military, my problem was there's a rule in the federal courts, and same with court martials, which is called a 413 motion. And what a 413 motion does is it allows the prosecution to bring in other juveniles, because my client had basically been accused of sexually assaulting a stepdaughter who was a minor. You get to bring in other people that have been assaulted that were minors or children, and they get to testify against your client and say that he has a character for assaulting children. So in other words, in most cases, you don't get to do this. So like if I have somebody downtown in a case that's maybe he's breaking into cars and he's breaking the windows and he's grabbing purses out of it, and he does it time and time again. If you go to trial with him, even though the prosecution would like to say he's got 14 convictions for breaking windows, grabbing the purses out of them, you should say that he's guilty of this time where the exact same thing happened in the exact same area, but you can't do that. So that's called propensity evidence, and it's not allowed. But there's one place it is allowed, and that's the place where when you've been accused of assaulting a child, sexually assaulting a child, 413 allows the prosecution to bring in other people that basically will say the same thing, and the jury's allowed to use that and basically use it against your client and say he has a propensity, or he has the kind of character to assault children. So in my case, this was the problem. I had to basically deal with my client who looked like he was a pedophile, looked like he was a serial pedophile. And what they were bringing in is, years ago, before this case happened, and it was outside the statute of limitations for child sexual assault, he had been accused of basically sexually assaulting two cousins. They were at an overnight party, sleepover, with all the family there, and that he had sexually assaulted them. Now, they were being called as witnesses at the trial. And so when they were called to testify against my client at trial with the jury in their presence, they basically testified that he had done this to them. They were very believable. I cross-examined them, but I didn't get very far on cross-examination because they seemed like they were telling the truth. So once the case went on, we got to a place where the alleged victim in this case, the stepdaughter, got up and she told what happened. Now, the problem with what she had said was, it was clearly she was lying. And my theory in the case was the reason that she was lying was that she had basically knew about these other two girls, her cousins, knew that these girls had been sexually assaulted, and what she was trying to do was right a wrong. She was up there and basically saying, well, I'll say that I was recently attacked by him. He was my stepfather, and I'm going to make this allegation. The problem was some of what she said just didn't make sense. I won't get into all the details, but there was some things that she said about the way the touching occurred, and him wearing like rubber gloves with things on top of it that would create friction that just could never happen. Where she said it occurred could never happen. And so on cross-examination with her, when I talked to her, as a good lawyer, I basically backed her into a wall, made it sound like she was lying, and went forward. But the problem was I still had to deal with, on closing arguments, the fact that I believed, and I knew the jury believed, that he had sexually assaulted these other children. And so what I did was, having faith in the system, I basically got up there and I gave my closing argument. And one thing I'm known for is giving good closing arguments. And I basically got up and I told the jury, I said, look, If you want to know what truth looks like, you saw it. It was these two girls that got up there and they talked about their pain. They talked about what happened to them, and they were victims, and they were the kind of victims that you should listen to and you should believe. And my client is a pedophile. There's no doubt that he's a pedophile. And the propensity argument and the propensity that the government is giving you today, well, guess what? They're right. He is that kind of person, and he has that kind of character. And when you look at what the alleged victim in this case basically said, it's clearly a lie. And you can balance what these girls said that were telling the truth against what you saw in the alleged victim in this case say, and what will happen is you'll see that this is a lie, and you should find my client not guilty of the charged offenses, because he wasn't charged with what had happened with these girls. He was charged with what the alleged victim had said had happened. So when I was done, and after they had come back and found my client not guilty, one of the most interesting things that happened is I was immediately fired. My client, although I had him found not guilty, he basically didn't like me calling him a pedophile, and in a court case, I owned my closing argument. So he had no say over what I was going to say to the jury, but he would have rather been found guilty, as weird as this sounds, and had me not call him a pedophile in front of that jury because he didn't like what I said and he didn't like the characterization. But I was surprised that the jury had done what they had done. This case has actually haunted me for a long time because I've always felt like if I was on that jury, I probably would have found him guilty. In my mind, the justice of the situation was he had done this, and this was an opportunity to transfer justice in using the alleged victim in this case. Even though she was lying, even though she was not sexually assaulted, this was a great way for them to basically come back, punish him for these other two victims. And I think the prosecution thought the same thing would happen. But one of the things when I tell this story is many people question the jury system and question whether the jury system works. And in this particular case, they did exactly what they were told to do. He was charged with one kind of offense. They didn't care what other people said, that the government had to prove this offense. And they held him to that standard, and they held the government to that standard. And I've always been proud of that jury, although I don't know that I was ever proud of myself. So there's a little story for you on a fun Friday. I'll take whatever comments. I might have some negative people that have some things that want to say about that, but that was the truth of a story that happened. And so chew on that for your weekend. Thank you.